Evening, everyone. My name is Başak Çalı, and I'm one of the co-directors of the Center for Fundamental Rights here at the Hertie School. And this evening, it's my pleasure to welcome Professor Mehrdad Payandeh to deliver the 2022 Distinguished Lecture. And the title of this lecture is Germany and the International Convention on the Elimination of All Forms of Discrimination. Professor Mehrdad Payandeh holds the chair for international law, European law, and public law at the Bucerius Law School in Hamburg, in Germany. He studied law in Düsseldorf at the Henry Heine University, also pursued an LLM at the Yale Law School, and then carried out his doctorate and habilitation also at the Henry Heine University. And he's currently based in Hamburg at the Bucerius Law School. Since 2020, Professor Payandeh is also a member of the Committee on the Elimination of All Forms of Racial Discrimination of the United Nations. This committee is an organ that is established by the Racial Discrimination Treaty, and it has the mandate to monitor the implementation of this treaty in all member states that have ratified the Convention on Elimination of All Forms of Racial Discrimination. Professor Payandeh's expertise spans really broad areas of public international law, European law, as well as EU law and public law and constitutional law. But of course, he also has a special interest in anti-discrimination law, and he, in 2019, published also on anti-discrimination with Professor Mangold, an important guidance on anti-discrimination, a book in German. In 2021, he was also part of the discussions about whether the German constitution should be amended with respect to how it tackles questions and concerns in relation to racial discrimination. This evening's distinguished lecture is going to focus on Germany and the International Convention on All Forms of Racial Discrimination. And in our earlier conversation, Professor Payandeh has also flagged that he wants to talk about how the CERD can be used in the most effective or in the most optimal ways to actually combat racial discrimination in Germany now and also in the future. So he also would like to focus on a more future-looking perspective on the matter. If we take it back to the history, of course, it's probably very important to note that the Convention on the Elimination of All Forms of Discrimination, all forms of racial discrimination, is the first United Nations Human Rights Treaty. And Germany is actually a state party to the convention since 1969. So it's one of the earlier ratifiers of this convention. And it has been in the monitoring system of the committee, which Professor Payandeh is now a member for a very significant amount of time. Before I give the floor to Professor Payandeh in just a few minutes, I also would like to perhaps flag the latest report from this committee in relation to Germany. You may be surprised that the latest official report, which is called Concluding Observations in the UN language, dates back to 2015. So we know that Germany has submitted its latest report in 2020, but it has not yet been discussed. This report is public, where the committee both says positive things about Germany's progress on combating all forms of racial discrimination, and also raises a number of concerns. And here I'd like to flag one particular issue which the CERD committee emphasizes. And this point is what the committee calls the state parties, which is Germany, state parties' reluctance based on its particular history to categorize its population by ethnicity, to collect data or segregated data in order to combat racial discrimination, and also its insistence of using terms such as persons with a migration background, but not further desegregated data in relation to how, monitoring and effectively complying with this treaty. The committee has, you may be surprised, quite a long list of concerns, or you may not be surprised, in relation to Germany's performance. And with that note, perhaps we can turn to Professor Payandeh and see what his take on is on the importance or the significance of this convention in bringing some meaningful, substantive changes in the discussions on racial discrimination in Germany. Thank you very much, Professor Payandeh, for joining us. We'll give you about 30 minutes or so for this lecture, and then there will be time for questions, comments, and a conversation with Professor Payandeh. So the floor is yours.
Thank you very much, Professor Başakçıali, for your more than generous introduction, and thank you also very much for the very kind invitation. I feel very honored to have been invited to give this distinguished lecture, in particular because I don't think I've ever done anything in my life before that has been labeled as distinguished or has been deserving of this label. So I'm very happy to talk this evening about the International Convention on the Elimination of All Forms of Racial Discrimination. I'm always very happy to talk about that convention, and in particular about the relationship between Germany and the convention, and I'm very much looking forward to comments, questions, and discussion. Before I begin, let me just add two very small caveats. First, to the effect that I'm a member of the committee, but today I speak, of course, only in my individual capacity. So my reading of the convention and of the obligations under the convention does not necessarily represent the view of the committee. And secondly, as Professor Charlie has just mentioned, Germany has submitted its most recent state report in 2020. And since this report still awaits consideration by the committee, it would not be appropriate for me to comment in any way on this report, or even more generally on whether and in how far Germany complies with its obligations under the convention. What I would like to do instead in the next approximately 30 minutes is to point out in a more general manner the potential of the convention, read in light of the practice of the committee, with regard to the understanding of the prohibition of racial discrimination within the German legal order. So I want to ask what can be gained, what could be an added value for current discussions taking place in Germany, and of course also in other places, concerning questions of race, of racial discrimination, and of racism, and what can be gained if we look to the international legal dimension of this discussion, so particularly at the Convention on the Elimination of Racial Discrimination and the practice of the committee. And I think that such an analysis can be of relevance and of interest for a number of reasons, and I just want to quickly point out three. Firstly, the German legal order is quite susceptible to impulses from international law. And I will come back to this point briefly at the end of my presentation when I try to look at the implications for the German legal order. Secondly, there are quite a lot of questions surrounding issues of race and racial discrimination in Germany, in particular with regard to how to address these questions from a legal perspective. Race and racial discrimination have, for quite a long time, not really played a prominent or meaningful role in German legal discourse, and this has changed only quite recently. In the wake of the killing of George Floyd and the Black Lives Matter movement, as well as the assassinations of Walter Lübcke in Kassel in 2019, the anti-Semitic attack in Halle, and the terrorist shootings in Hanau in 2020, to name just the most horrific incidents which have also received the most attention. And I think it's fair to say that discussions on what this newfound attentiveness to racial discrimination means from a legal perspective and what the law can actually contribute to combating racism, those discussions are still at a rather early stage. And against this background, looking to an international legal regime, which has been dealing with these questions for more than 50 years now, can prove to be quite fruitful. And thirdly, looking at Germany from the perspective of the convention can provide some general insights into the significance of international human rights treaties, in particular for Western states or states from the global North. Again, I think it's fair to say that when Western states join human rights treaties, they generally don't expect that they have to adapt very much in order to fulfill the obligations they entered into. After all, they are Western democratic states with comprehensive fundamental rights protections in their constitutions and with a sophisticated system of judicial protection. And I hope that looking at the convention and the practice of the committee can help to overcome this widely shared misconception, which I might have just slightly overdrawn a little bit for the purpose of dramatization. So in the following, I will approach the topic in 4 steps. I will first, and by way of a very short introduction, take a quick look at the International Convention on the Elimination of All Forms of Racial Discrimination in general. I will then secondly turn to the definition of racial discrimination under the convention and try to point out what lessons can be learned with regard to current debates in Germany on the concept of race. Thirdly, I will look at the dimensions of discrimination that are covered by the convention, in particular with regard to how the convention addresses structural forms of discrimination. It's a topic which is also discussed in Germany. And fourthly and finally, I will conclude with a quick look at the implications of these aspects for the German legal order. So first, a very brief introduction to the International Convention on the Elimination of All Forms of Racial Discrimination. The convention is an international treaty which was adopted in 1965 and entered into force in 1969, making it the oldest of the 9 core human rights treaties, which together with the Universal Declaration of Human Rights constitute the normative foundation for human rights protection within the United Nations. 182 states are party to the convention, so it is of a nearly universal character. As regards its content, the convention is basically divided into 2 parts. A substantive part containing the obligations that states must comply with, and an institutional or procedural part, which establishes the Committee on the Elimination of Racial Discrimination, as well as various mechanisms for the committee to engage with the question of member states' compliance with the convention. Turning to the first part of the convention, the substantive obligations under Article 1 to Article 7. At the heart of the convention is the prohibition of racial discrimination. Now, other human rights instruments and constitutional provisions of states usually deal with this topic in a rather short manner, basically by stating that discrimination on the basis of race, and sometimes adding ethnic origin, is prohibited. The convention, on the other hand, needs 7 articles to lay down what is meant by racial discrimination and to outline the obligations states have in connection with racial discrimination. So here, the convention is much more specific than other human rights treaties or constitutions. It does not only prohibit racial discrimination by states and state agents, but also establishes rather far-reaching obligations to protect from racial discrimination. It prohibits hate speech, and it obliges states to actively prevent and react to instances of racist speech. Accordingly, the convention has rather far-reaching implications for racial discrimination in a society, going so far as to oblige states to guarantee freedom from discrimination with regard to housing, the workplace, or access to transport, hotels, restaurants, as well as other public places and venues. What else does it do? The convention requires effective protection and remedies in case of racial discrimination, and it obliges member states to actively combat racial prejudice by means of information and education. So it actually goes beyond basic human rights guarantees, and it has a rather far-reaching transformative potential. So much as a very quick introduction to the substantive parts of the convention. Now, the second part of the convention, starting with Article 8, turns to the question of implementation and supervision. Here, the convention establishes the Committee on the Elimination of Racial Discrimination, one of the 10 Geneva-based UN treaty bodies composed of independent experts. The members of the committee are elected for a 4-year term by the state's parties, but they nonetheless serve as independent members in their individual capacity. This is actually the main feature distinguishing the committee and the treaty bodies in general from other UN bodies, such as the Human Rights Council, which is composed of representatives of states and not of individual members. The main task of the committee then is to supervise the implementation of and compliance with the convention by the states parties. For this purpose, the convention basically establishes 3 procedures. Firstly, states have to periodically submit reports on how the guarantees of the convention are implemented. The committee will then scrutinize these reports in a dialogue with the state and on the basis of information submitted by civil society organizations as well as by other UN entities. At the end, the committee will issue concluding observations, highlighting some positive developments, as well as pointing out concerns and making recommendations to the state. Secondly, states have the possibility to submit disputes with other states parties under the interstate communication procedure. The ICERD is actually the only human rights treaty that makes this procedure compulsory, which is also the reason why in 2018, the first ever 3 interstate communications under any UN human rights treaty have been launched under the ICERD, namely Qatar versus the Kingdom of Saudi Arabia, Qatar versus the United Arab Emirates, as well as the State of Palestine versus Israel. All 3 procedures are, let's just say, not completely uncontroversial. The third procedure under the ICERD is the individual communications procedure. Under this procedure, an individual that feels that his or her rights under the convention have been violated by a state party can submit a complaint, and the committee will then decide whether a violation has taken place and will make recommendations accordingly. This procedure, however, is optional, meaning that it only applies to states which have declared their acceptance. And under the ICERD, only 59 of 182 states have made such a declaration, recognizing the competence of the committee to receive and consider individual communications. The committee has, as have other treaty bodies, developed further mechanisms to fulfill its mandate. It has, for example, established a so-called early warning and urgent action procedure in which it can send letters to state parties or issue decisions or statements. It has actually issued a statement today on the question of racial discrimination at the border of Ukraine with regard to refugees, with regard to people who want to leave Ukraine. And furthermore, the committee develops so-called general recommendations, which deal with specific aspects of the convention or issues that arise under the convention, such as racist hate speech, for example, or racial profiling by law enforcement, to name just the 2 most recent recommendations. So by way of summing up, the committee has a number of mechanisms through which it can voice concerns about states' compliance with the convention. It can also utilize these mechanisms to clarify and to further develop the obligations that states have under the convention and thereby contribute to the interpretation as well as the application of the convention. Now, what is the specific potential of the convention and of the practice of the CERD from the perspective of a state such as Germany? I just want to point out 2 discourses within Germany and the German legal order, which in my opinion could profit quite tremendously from a deeper engagement with its international legal counterparts. The first concerns the basic question of who is actually protected by the prohibition of racial discrimination. In Germany, this question focuses on the constitutional prohibition under Article 3, paragraph 3 of the Constitution, which basically states that no person shall be favored or disfavored on the basis of his or her race. In this context, a number of issues are subject to discussion. How should we understand the term race against the background that race does not have a biological foundation? What do we do with the generally shared insight that race does not exist, but that as a social construct, nevertheless, it shapes society in important ways and it impacts the life of so many people? And does the term race encompass all forms of racism? Does it cover anti-Semitism? Does it cover Islamophobia? Is it applicable to unspecified forms of xenophobia that are not directed against members of a specific quote unquote race or against foreigners in general or refugees? Does it encompass that? If we look at standard definitions of race, as they can be found in well-established commentaries on the German Constitution, those are regularly not very helpful. They keep focusing on distinctive hereditary features as markers of race, despite the general consensus that race is not a biological category. The confusion and the limited practicability of the term race contributes to quite a noticeable reluctance of German legal practice to actually engage with racial discrimination at all. And it leads to controversial debates as to whether the term race in the German constitution should be replaced by another concept such as ethnic origin or racial or even racist discrimination. Despite the occasional tip of the hat or lip service, the International Convention Against Racism is astonishingly absent from the debates in Germany. This is even more unfortunate since the convention has a rather pragmatic and hands-on approach to the question of race. It actually does not define the term race, and it also does not move the term into the center of the concept of racial discrimination. Article 1, paragraph 1 of the convention rather defines racial discrimination as any unequal treatment based on race, color, descent, or national or ethnic origin. So it has a very broad definition. And this very broad definition also releases the committee from the burden of having to come up with a definition of race, an endeavor which would prove to be rather futile anyway, in my personal opinion. And it's also quite clear that the 5 concepts I've just mentioned and the way they are enumerated in Article 1 do not constitute clear-cut criteria with a fixed meaning. As one long-term member of the committee has put it, the definition was composed by adding as many concepts as possible in order to avoid any lacunae. Accordingly, the practice of the committee can be characterized as rather pragmatic. On the one hand, the committee has identified certain groups which are generally vulnerable to racial discrimination: Africans and people of African descent, Asian people, indigenous peoples, and members of the Roma community, for example. On the other hand, the committee does not resort to seemingly objective criteria such as skin color or ancestry in trying to identify groups which are protected under the convention. It rather focuses on social practices and on patterns of discrimination. It focuses on how groups are perceived within a specific society and in how far members of a group actually identify as a specific group. The committee therefore does not have any difficulties to include, for example, migrants and non-nationals among the protected groups. And while there have been at times debates, for example, as to what constitutes an indigenous people, whether distinctions according to caste fall within the scope of the convention, and how far the protection of non-nationals as such actually goes, the states parties to the convention have in general accepted the approach of the committee. What conclusions can be drawn from the approach of the convention and the practice of the committee for the discussions in Germany? The focus of the discussion in Germany on the term race seems quite understandable in light of the fact that this is actually the term that the German constitution uses. But international experience shows the futility of trying to come up with a clear-cut definition of race that would be fit for the purpose of legal application. Who is to be protected under the prohibition of racial discrimination cannot be determined in the abstract, but only with regard to existing patterns of discrimination and exclusion, and with regard to existing social practices in which groups are constituted either on the basis of perception or attribution by others, or on the basis of self-identification of the members of such groups. The prohibition of racial discrimination is not occupied with race, but rather with racism and with racial discrimination. The focus of the legal discourse should be aligned accordingly. Let me come to a second discourse in which the convention and the committee can provide some insights concerning the structural dimension of discrimination. As is well known, discrimination as a social phenomenon can take many different shapes and forms. It can manifest itself in intentional acts of discrimination by individuals. It can come along in more subtle ways, for example, in actions or practices which do not directly discriminate against certain groups of people, and maybe not even on purpose, but which lead to discriminatory results. And discrimination can have an even more structural dimension, which is also even more difficult to grasp. Structural discrimination can refer to social, economic, cultural, and political circumstances that disadvantage specific groups. It finds expression in different ways, such as insufficient representation of a specific group in political institutions and structures of participation, socioeconomic disparities, or tendencies of segregation, for example, with regard to the labor market, housing, or education. On the basis of this understanding, structural discrimination refers first and foremost to an empirical phenomenon. Whether it has any specific legal implications is hardly ever addressed in German legal discourse. If we look at commentaries on constitutional law, those regularly do not deal with structural discrimination, although more recent contributions seem to indicate a tentative change. A survey of the convention and of the practice of the committee, however, brings to light numerous contexts in which instances of structural discrimination can gain relevance from a legal perspective. Let me just very roughly sketch out some entry points for the concept of structural discrimination into the legal discourse. First example, take direct discrimination. For determining whether an act of direct discrimination has occurred, the structural dimension of discrimination does not seem to be relevant, at least at first glance. But if we look, for example, at racial profiling by law enforcement, the picture might look a little bit different. Seemingly random identity checks or security controls carried out by the police constitute direct discrimination when the decision whether a person is subjected to such a control is influenced by that person's skin color or other phenotypic features. A quick glance at the practice of German administrative courts, however, shows some remarkable blind spots in this regard. The degree of interference with the rights of a person who is subjected to identity checks is regularly deemed to be rather low. After all, the person is merely stopped and asked to show an identity card. And there are also instances in which the courts are rather skeptical and reluctant with regard to recognizing whether race has played a role at all, even if a person has been subjected to such identity controls numerous times and more often than other persons. Taking into account the structural dimension of discrimination could sensitize the courts with regard to the stigmatizing effects of such seemingly low-intensity interferences. It could lead to reflections on the wider implications discriminatory controls can have for the level of trust that people of color, for example, have in state institutions and in the judicial system. And it could highlight that implicit bias and unconscious stereotypes play an important role in the decision of who is subjected to an identity control and who is not. So that even when a police officer credibly and convincingly argues that race did not play a role in the decision, measures must be taken to ensure that this is actually the case. Statements of the CERD can provide some useful guidance in this regard. Second example, the duty to protect. Under the convention, states not only have the obligation to not engage in discriminatory acts, but they also have the duty to protect members of vulnerable groups from acts of discrimination. The structural dimension of discrimination plays an important role in this context. On the one hand, systematic instances of discrimination and widespread discriminatory practices can activate the duty to protect. States are required to react to such practices and patterns, to take preventive measures, as well as to react to specific instances of discrimination. On the other hand, measures taken in implementing the duty to protect can aim at improving the overall situation and at changing the structures which facilitate or support discriminatory behavior. In this regard, the committee, for example, highlights that states not only have the duty to make racist hate speech a punishable offense, but also that they must take active measures to combat hateful stereotypes and to take initiatives aimed at, for example, making education more sensitive to issues of discrimination or avoiding the use of harmful stereotypes or the dissemination of racist speech in the media. Third and final example, special measures. With regard to gender equality, affirmative action has been on the agenda of German political and legal discourse for many years. By contrast, measures taken to support people of color in advancing professionally have only recently been taken into consideration. In Berlin, for example, discussions surrounding a quota in public administration for people with a migration background have led to controversial debates. And timid discussions of whether academic scholarship programs should be established specifically for Black students have only just begun. There is hardly any debate on whether and under which circumstances such forms of affirmative action would be admissible. My semi-educated guess would be that many constitutional law scholars are rather inclined to dismiss this possibility, as it would constitute positive or reverse discrimination prohibited under the German Constitution. The Convention, however, applies a more nuanced approach, clearly taking into account the structural dimension of racial discrimination. The Convention explicitly states in Article 1, Paragraph 4, that measures taken for the purpose of securing adequate advancement of certain racial or ethnic groups do not constitute racial discrimination and are therefore allowed. In the next article, it even goes one step further when it states that under certain circumstances, such special measures are not only permissible, but rather compulsory. These three examples should suffice to show that under the Convention and in the practice of the committee, structural discrimination plays an important role. From a legal perspective, structural discrimination does not constitute a distinct form of discrimination, but can rather be understood as an analytical concept, which can be useful in interpreting and applying the obligations of states with regard to the prohibition of racial discrimination. Dear colleagues, dear listeners, let me finish with some concluding remarks. I hope that I succeeded in indicating in how far the International Convention on the Elimination of All Forms of Racial Discrimination can prove to be insightful when it comes to fundamental questions of race, of racial discrimination, and racism within Germany and within the German legal system. But are the Convention and the practice of the committee merely impulses and sources for inspiration and fruitful insight? Of course not. The Convention is legally binding, and the practice of the committee, while not formally binding, nonetheless has a normative dimension and is to be taken into consideration when interpreting and applying the Convention. This does not mean that international law requires constitutional provisions on racial discrimination to be interpreted and applied strictly in the same manner as the provisions of the Convention. However, the Federal Constitutional Court of Germany, in its well-established jurisprudence, highlights that obligations under international law have to be taken into consideration when interpreting the German Constitution, in particular as far as international human rights law is concerned. The court has developed this approach with regard to the European Convention on Human Rights, but it has also applied it to United Nations human rights treaties, in particular to the Convention on the Rights of People with Disabilities. As far as the text of the German Constitution is open towards such an interpretation, obligations under international human rights law therefore have to be taken into consideration. Against this background, there do not seem to be any compelling reasons to read the prohibition of racial discrimination under German constitutional law in a more narrow or more restrictive manner as under the Convention. The clear recognition of the structural dimension of discrimination under the Convention would also make it rather difficult to refuse any engagement with this phenomenon in the context of the constitutional prohibition of racial discrimination. And in light of the Convention's clear holding that affirmative action may not only be permissible, but possibly even required, any understanding of the Constitution that would exclude the possibility of affirmative action would hardly be compatible with the Convention and with the much emphasized openness of the German Constitution towards international law. I thank you very much, and I look forward to questions, comments, and discussions.
Thank you very much, Mehrdad, for this lecture. This was incredibly comprehensive, and I think it will open up a wide range of questions also from our audience this evening.